to the amendment in question, read with the decision of this court in Pramati Trust, the answer to the issue framed in that regard would also be against the change. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. 1. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. 2. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. 3. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, SPs from the scope of EWS reservation. Consequently, the transferred cases, transfer petitions, read petitions, and the petition for special leave to appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice Bela Trivedi to place her view.
I have concurred with the opinion of Brother Justice Maheswari. However, I have penned down certain my views also. I'll just read them out. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it. In the instant case, the legislature, being aware of the exclusion of economically weaker section of the citizens from having the benefit of reservations provided to the SCs, STs, and SCBCs citizens in clause 4 and 5 of Article 15 and clause 4 of Article 16, has come out with the impugned amendment in empowering the state to make special provisions for the advancement of EWS other than the classes mentioned in clause 4 and 5 of 15 and clause 4 of Article 16. The impugned amendment enabling the state to make special provisions for EWS of citizens other than SCs, STs, and SCBCs is required to be treated as an affirmative action on the part of the Parliament for the benefit of and for the advancement of the EWS of the citizens. Treating EWS of citizens as a separate class would be a reasonable classification and could not be termed as unreasonable or unjustifiable classification, much less a betrayal of basic feature or violative of Article 14. As laid down by this court, just as equals cannot be treated as unequals, unequals also cannot be treated as treated equally. Treating unequals as equals would be as well offend the doctrine of equality enshrined in Article 14 and 16 of the Constitution. The SCs, STs, and backward class for whom the special provisions have already been provided in Article 14, 15.4, 15.5, and 16.4 form a separate category as distinguished from the general or unreserved category. They cannot be treated at par with the citizens belonging to the general or unreserved category. The impugned amendment creates a separate class of EWS from the general or unreserved class without affecting the special rights of reservations provided to the SCs, STs, and SCBCs. Therefore, the exclusion from the newly created class for the benefit of EWS in the impugned amendment cannot be said to be discriminatory or violative of Equality Code. Such amendment could certainly not be termed as shocking, unconcernable, or unscrupulous travesty of quintessence of equal justice as sought to be submitted by learned counsels for the petitioners. The sum and substance is that the limitations, that is substantive or procedural, imposed on the exercise of constituent power of the state under Article 368 could not be said by any stretch of imagination to have been disregarded by the Parliament. Neither the procedural limitation, that is the mode of exercise of amending power, has been disregarded, nor substantive limitation, that is the restricted field, has been disregarded, which otherwise would invalidate the impugned amendment. What is visualized in the preamble and what is permissible, both in Part 3 and Part 4 of the Constitution, could not be said to be violative of the basic structure or basic feature of the Constitution. In absence of any obliteration of any of the constitutional provisions and in absence of any alteration or destruction in the existing structure of equality code or the basic structure of the Constitution, neither the width test nor the identity test as propounded in Keshwanand could be said to have been violated in the impugned amendment. Accordingly, the challenge to the constitutional validity of 103rd Amendment fails and the validity thereof is upheld. And before parting, I have expressed my views on the time span to be prescribed for the reservation policy. I have quoted the observations made by the Constitution Bench in K.C. Vasant Kumar, observations of Justice D.A. Desai, Justice Venkatramaiah, Justice Chandrachud as he then was, and also in the case of Ashok Kumar. And at the end, I said, what was envisioned by the framers of the Constitution, what was proposed by the Constitution Bench in 1985, and what was sought to be achieved on the completion of 50 years of the advent of the Constitution, that is, the policy of reservation must have a time span, has still not been achieved even till this day. That is, till the completion of 75 years of our independence. It cannot be gainsaid that the age-old caste system in India was responsible for the origination of this reservation system in the country. It was introduced to correct the historical injustice faced by the persons belonging to the SCs, STs, and other backward classes, and to provide them a level playing field to compete with the persons belonging to the forward classes. However, at the end of 75 years of our independence, we need to revisit the system of reservation in the larger interest of the society as a whole, as a step forward towards the transformative constitutionalism. Be it noted that as per Article 334 of the Constitution, the provisions of Constitution relating to the reservation of seats for SCs and STs in the House of People and in the legislative assemblies of the states would cease to have effect on the expiration of the period of 80 years from the commencement of the Constitution. The representation of Anglo-Indian community in the House of Parliament and in the legislative assemblies of the state by nomination has already ceased by virtue of 104th Amendment, that is with effect from 25th January 2020. Therefore, similar timeline, if prescribed, for the special provisions in respect of the reservations and representations provided in Article 15 and 16 of the Constitution, it would be a way forward leading to an egalitarian, casteless, and classless society. Thank you so much.
May I now invite Justice Paradiwala to place his view.
While concurring with my esteemed brother, Justice Maheswari, and my esteemed sister, Justice Trivedi, and while upholding the validity of the impugned amendment, I have thought fit to observe, I quote, thus, reservation is not an end, but a means to secure social and economic justice. Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tapering the gap between the classes to a considerable extent. As larger percentages of backward class members attain acceptable standards of education and employment, They should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Baba Saheb Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation.
Big breaking news now coming in. The Supreme Court has upheld the 10% reservation. So the economically weaker section quota has been upheld by the Supreme Court. Big development coming in from the top court, one that is going to have far-reaching consequences. The Supreme Court has upheld the quota for the economically weaker sections, saying that it does not violate the Constitution. So the judges back the quota. Nilashish joining us live with the details. Nilashish, big development. 3 of the 5 judges upholding the 10% quota for the poor.
Well, absolutely. 4, in fact, now out of the 5 judges have concurred, saying that the EWS quota does not violate the Constitution. It has been said initially by Justices Maheswari, also reading the judgment on behalf of himself and the CJI, thereafter by Justice Bela Trivedi, and now Justice Pardiwala. All 4 have concurred, saying that the EWS quota does not, in fact, breach the Constitution in any way. It has been stated that reservation is an affirmative action, and reservation solely on the basis of economy of a person on an economic basis does not violate the Constitution. It has also been stated that exclusion of SC and ST and OBCs from EWS quota is constitutionally valid. Now, Justice Trivedi also stated that the amendment has to be treated as an affirmative action by the Parliament for the benefit of the EWS class. It cannot be said to be an unreasonable classification. So, of course, dispelling the worries and the issues raised by the petitioners in this case, 4 of the 5 judges at this point, it is a majority judgment so far. We have to see if it's a unanimous judgment or not. One more judge is remaining in terms of his delivering his judgment, but it has been said by Justice Maheswari as well that the 103rd constitutional amendment for EWS quota is valid and does not violate the basic structure of the Constitution. So very significant judgment coming in at this point from the Supreme Court, wherein it has been held that reservation is affirmative action, that the exclusion of caste, which is SCs, STs and OBCs from the EWS quota is constitutionally valid. It does not breach the Constitution. It is not against the basic structure of the Constitution. So yes, very significant judgment coming in at this point. Justice Ravindra Bhatt also, in fact, is now pronouncing his judgment, wherein so now what we have is Justice Ravindra Bhatt disagreeing with the majority verdict. So we can tell our viewers that it is a 4:1 judgment now as far as the Supreme Court is concerned. Justice Ravindra Bhatt has given a minority judgment saying that he disagrees with the majority verdict, that it is constitutionally valid. However, what has been stated as far as the Supreme Court majority judgment is concerned is that reservation is affirmative action, that providing reservation to economically weaker sections does not violate the Constitution at all. The EWS reservation, in addition to the 50%, remember that was the claim, because reservation was already at 50% basis SCs, STs and OBCs in admissions, in jobs. It has been stated that EWS reservation, in addition to the 50% of the available seats, is constitutional, and this is because the ceiling limit itself is flexible and only applies to caste-based reservation. So the contentions that the 50% ceiling has been breached has not been taken up by the Supreme Court. It has not held water with the court, because they are saying that over and above the 50%, it continues to be valid because the reservation is based not on caste and it is not an inflexible ceiling. So it is clearly stated that the ceiling limit itself is flexible, and therefore this particular reservation is valid as far as the law is concerned. So the Supreme Court upholding EWS reservation by a majority of 4:1.
Absolutely. And Nilashish, like you mentioned, Justice Bhatt dissenting with the view saying that this is unconstitutional, but the other judges in the case, because it was a 5-judge bench, the 4 judges in the bench said that there is validity of the constitution in the verdict that has been given. They said, in fact, also hailing, and this is coming as a big boost to the Modi government because it hails and says that this is a landmark moment for the country.
Well, absolutely. Of course, given the nature of this judgment, it is very, very essential and very significant. Not just politically, socially as well, the kind of dissemination of this judgment into the economic stratas of society, the weaker sections, will be very, very significant. Of course, it has been said that as far as the reservation is concerned, over and above the 50% limit, it is valid because it is not based on caste, it is based on economic viability, and it is an affirmative action. That is a very, very significant aspect that has been highlighted by Justice Maheswari as well as Justice Bela Trivedi. Of course, Justice Maheswari's judgment was also on behalf of the CJI as well. So 3 judges really saying and talking about the affirmative action taken by the Parliament in order to in fact give more opportunity to the economically weaker sections. Now, as far as this particular judgment is concerned, of course, it has been also stated that it does not violate the basic structure. Now, as far as the main case is concerned, that is the Indra Sawhney case, which is always spoken about when it comes to reservation, when it's said that there cannot be a breach of a certain percentage of reservation. That is a very, very significant aspect wherein the court has said that the limit, the ceiling, is flexible given the fact that this is not based on caste.
Absolutely. Very, very significant. And in fact, in one of the arguments that had been made by the government as well, Nilashish, had been that it will not erode the rights of the SCs, STs and the OBCs, because one of the petitions had also said that it takes away the rights of those who have been given reservations until now.
Well, absolutely. The reservation, again, in this, as we have been saying, as the Supreme Court just held, it is excluding that of the SCs, STs and OBCs. The reservation that has been granted is based on economically weaker sections, and that is a distinction that has been clearly made out by the 4:1 majority of the Supreme Court Constitution Bench. As we speak, they have said that it excludes that caste reservation that is already in place as per Indra Sawhney, wherein it was 50%. However, when it comes to the economically weaker section, the 10% is a completely different criterion on which reservation is made, and that is completely exclusive of each other. Therefore, this does not go against the basic structure. This does not violate any of the rules and the laws as far as reservation is concerned, and also it does not really breach the constitutional, the basic structure of the Constitution. Therefore, it is held to have been valid.
Okay, all right. Nilashish, stay with us. Let's apprise our viewers. Landmark judgment by the Supreme Court. It's with a 4-1 majority. The Supreme Court upholding the reservation of 10% for the economically weaker sections. Remember, it was a live broadcast in the Supreme Court that we just played out for you. 1 judge dissenting, but the 4 judges concurring that this is constitutionally valid. So the 10% quota for the economically weaker sections holds. This after marathon sessions in the Supreme Court where it heard arguments against it. So this could also have a big political impact coming ahead of the elections. Stay on with us.